Okay, well, welcome everybody to Victoria University. Thank you very much for giving up your lunchtime to come along and participate in this event. My name is Nicole Moreham. I'm an associate professor here on the faculty, and I'm giving this presentation along with Martin Beckier, PhD candidate here at Vic, who's sitting there at the front. Now, as you're hopefully all aware, the topic of this talk is privacy, why should we care? And we're going to divide it into three roughly equal sections. So the first one, I'm going to talk about exposure, which I'll explain a little bit more in a moment. Martin is then going to talk about data acquisition, particularly in the commercial context. And then the final third of the talk will be devoted to questions and any comments that you might have from the floor. So we hope to wind up at about 1:15. So, exposure. Why should we care about breaches of privacy that involve exposure? Or more particularly, the question that I want to address in this part of the talk is why do we care about breaches of privacy that involve exposure? Because I think it's reasonably safe for me to assume that most of us are affected somehow if somebody breaches our privacy by finding out information about us, or by looking at us or listening to us when we're engaged in something which wasn't intended for their observation. The question I want to look at then is not so much why should we care, but how do we articulate the feelings which I think most of us do have about what's wrong with that, about why we don't like it when somebody breaches our privacy by exposing us. Well, before we answer that question, I think we need to look at a prior one, and that is, what do I mean, or what do we mean when we talk about privacy, particularly when we're talking about privacy in the context of exposure? And I think there are two main aspects to this which have been widely accepted both by lawyers and by theorists. And the first one is that you can breach a person's privacy by finding out something about them, by finding out private information about them. Now, most of us can probably imagine what a breach of this nature might look like. There are lots of classic examples of private information that many people share similar feelings about. I've got some examples that are typical in the case law and in theory. One is medical information. Most people have something in their medical records that they don't want disclosed. Maybe they've got an STD or they've had an abortion. Maybe they've got sexual dysfunction or incontinence, anything like that. Maybe they've got ingrown toenails, but most of us don't have something in our medical records that we don't want shared. Sexual information is another classic example. Few people want all of the details of their sexual lives and history made public. Sometimes we're a bit sensitive about financial information. Sometimes that's because we're perhaps not as well heeled as we look. Sometimes it's because we're better heeled than we look. So we have another example of the kind of information that some people might regard as private. So that's the first category. Fairly well understood, finding out private information about someone against their wishes. There's a second category as well. This one is about looking at someone or listening to them or recording them against their wishes. Now, sometimes when you do this, you'll find out information about somebody, but not necessarily. Because often the objection in a situation like this is actually just to the looking or to the listening or to the recording itself. It's what I sometimes call the creepy talk, the creepy stuff. So, to use an example from the leading New Zealand case and the leading Italian case in Canada, maybe our flatmate or our landlord is videoing us in the shower without us knowing. Or, this is a headline from last week, maybe there's a guy who likes to check into the hotel room beside us so that he can use a peephole to have a look at what we're doing in the room. Maybe we had the misfortune to check into the motel room of this guy who installed hidden vents in the ceiling of the motel so that he could watch paying guests having sex in the units over a period of 29 years. I'll tell you what, if you look at the US case law for too long, you start to get very paranoid when you go into a motel room or a service station toilet. That's one set of examples, but maybe someone's photographed us when we're in shock or we've just had a trauma. This boy's father's just been shot in front of him and he's being led into a hospital. Maybe we're overcome with grief or with some other extreme emotion that we'd normally wish to keep behind closed doors. Now, both of these types of privacy, finding out information about somebody and looking at or listening to a person have been recognised by New Zealand courts as key parts of the privacy interest. And so that's what I mean when I talk about privacy by exposure. So why do we care about it? How do we articulate why we care about it so that the importance of this interest can be weighed appropriately against other important interests like freedom of expression or access to justice? Well, the answer to that question that is most often given is that privacy is important because it's an essential aspect of dignity and autonomy. So it's widely accepted by judges and by theorists that privacy is important because because our ability to choose how and to whom we reveal ourselves is an essential part of what it is to be human. So we say it's a fundamental part of our dignity that we should be able to make decisions about that aspect of our lives. Now, the flip side of that is that to breach someone's privacy, to look at them when they don't want you to find out about them when they don't want you to, is to treat somebody's life, their naked body, their health information, their sexual intimacy, their tragedy, somebody else's life as something simply for you to do something with. Maybe you want to entertain, maybe you want to make money, maybe you want to titillate. But the essential point is that it's you that's doing the choosing and not them. Now, those of you with a passing acquaintance of philosophy might recognise that these ideas are emanating from the late 18th century philosopher Immanuel Kant. This is all about the idea of not treating somebody else as a means to your ends. The idea that you need instead to treat somebody as a chooser, just like yourself, somebody who is just like you, trying to cast a way through their life and making decisions about when and how they should be exposed to others. Now, this has been recognised in the New Zealand case law as the essence of the New Zealand privacy right. And so here's the leading privacy case, the New Zealand Court of Appeal decision, Hosking and Runting. This is Justice Tipping, saying it's the essence of the dignity and personal autonomy and well-being of all human beings that some aspects of their lives should be able to remain private if they so wish. Likewise, Brooker and Police, this is Justice Thomas in the Supreme Court. Probably no human right is more basic to human dignity than privacy. It's within a person's sphere of privacy that the person nurtures his or her autonomy and shapes his or her individual identity. I could give you similar quotes from the US and from English case law. So the language of dignity and autonomy is increasingly used in law to describe what it is that we're talking about when we look at breaches of privacy. And I think it's interesting, too, that we also hear this language, the language of dignity, coming through in the descriptions which individuals give, ordinary individuals give, of what it's like to have their privacy breached. So the first couple of quotes I'm going to have here come from family members of the men who were lost at Pike River. My colleague Yvette Tinsley and I have done an empirical study into the experiences those people had of the media in the aftermath of that event. This is some of the words that they've used to describe how they felt they were being treated. We were just a story. We seemed violated by them all the time. We see the same language coming from the victims of phone hacking in the UK. This is the systematic phone hacking that was undertaken by tabloid newspapers against certain public figures. Some of them were phone hacked twice a day for 7 years. These people have said, we were just pieces of news to be played with. Or, we felt violated, we felt sickened, persecuted, hunted. So again, I think what we're seeing here is the language of Kant, the language of dignity. I think what these people are indignant about is the failure to treat them as people. We weren't being treated as people, we were being treated as a story, we were being treated as something to be used to the ends of the people who wanted to talk about us or to report about us. So that's the first reason why I think we should care. But it's important to emphasise that privacy isn't just about taking ourselves away from others. It's not just about sitting in a room and scribbling in our diary or heading to the hills to live as a hermit. Privacy is also a really important part of our interactions with one another. And so theorists in particular have acknowledged that privacy is necessary for the facilitation and the maintenance of relationships. Now, my sister is in the audience. bless her. Now, I could invite her down here and we could have a conversation in front of you, but you wouldn't be surprised to hear that that would be a different conversation to the one that we would have if you weren't here, if we were in our kitchen or if I was talking on the phone. And that's entirely as it should be, because the definition of intimacy, of friendship, of love, of familial ties involves the idea that you disclose some things to your intimates that you don't disclose with others, that you share some things with them that you don't share with others. Now, in order to be able to do that, you need to be able to exclude others. We need to be able to be with our friends, to be with our lovers, to be with our intimates without other people being there. As one theorist puts it really nicely, Stanley Ben, we cannot carry on personal conversations under the same conditions as an open seminar. Now, again, we see that being played out in the case law and in popular discourse about privacy breaches. I think it's what is at the essence of celebrities' complaints when they're being followed around all the time by the paparazzi. Lorde, for example, has complained about this kind of image, about the impact that it has on her ability to live a normal life. Dan Carter has complained about images of his son appearing and the impact that that has on his ability to create a normal family environment for him. And again, we also hear it played out in people explaining the effects of intrusions on their lives. Here again is a quote from a family member at Pike River. She's talking about the particular incident, which some of you will recall, when they came out of that meeting when they were told that the men had definitely died. And she was talking about the effect of having the media there. She said, I really hated it because it was a private moment for the families. We just wanted to be with one another and support one another, but we couldn't do that outside because when you stopped and talked to another family member and you had your arms around them, the cameras were on you and they were just there. So not only is she objecting to the fact that the cameras were there, but she was saying the cameras took away that moment from them. It prevented the intimacy that they were seeking. So that's the second reason. That's the final one that I'm going to deal with. So what is it that I want everyone to take from this? Well, I guess the first thing is that privacy is important, that the right to be free from the searing effects of exposure is important. That's not to say, I should stress, it's not to say that they should always prevail, those interests, because there are very important rights on the other side. We have interests in open justice and we have interests in freedom of expression, which break down in terms of the right of the public to be informed, breaks down to your right to tell your own story, even though it might involve somebody else. And it's also about the right to expose wrongdoing, whether on a societal level or on a personal one. Those are very important rights which are weighed up against privacy. What I think we can insist on, though, is that when privacy squares off against these heavyweights, that it is a fair fight, that the privacy rights are properly understood and that they're properly articulated so that they can weigh against things like access to justice and freedom of expression at least on an equal footing where appropriate. Thank you.